Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today, we'll break down the May 14th, 2026 opinion, Jules versus Balazs Properties. The Supreme Court ruled unanimously, 9-0, that federal courts keep their jurisdiction to confirm or vacate arbitration awards even when those motions don't independently present a federal question. Justice Sotomayor wrote the opinion for the entire court. No separate concurrences, no dissents.
This matters because it clarifies that when you sue in federal court and get sent to arbitration, the federal judge who sent you there can also handle the endgame, confirming or tossing out the arbitrator's decision.
And here's a fun fact. This might have been the quickest case from argument to opinion. It took 45 days for the court to hear the case and issue their opinion. Most cases average over 100 days. But from listening to oral arguments, it became clear the justices already decided the case in their minds.
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
Here's what you need to know.
Adrian Jules worked at the Chateau Marmont Hotel in Los Angeles between 2017 and 2020. Famous hotel, famous clientele, iconic West Hollywood location. Before Jules started working there, he signed an arbitration agreement saying any employment disputes that couldn't resolve through negotiation or mediation had to go to arbitration, not court.
Standard employment contract language these days.
Exactly. Then March 2020 arrives. COVID hits. The hotel terminates Jules' employment, citing pandemic-related staffing issues. Jules thinks something else motivated his firing, so he sues Balazs Properties, the company behind the hotel, plus related entities. Files in federal court in New York because that's where several defendants maintain their principal places of business.
And he brought federal claims. Employment discrimination under federal law.
Right? Federal discrimination claims plus state law claims. That federal claim gives the district court original jurisdiction under what lawyers call federal question jurisdiction. Basically, when your lawsuit involves federal law, federal courts can hear it. But the defendants point to that arbitration agreement Jules signed and say, hold on, you agreed to arbitrate employment disputes. So they move to stay the federal case pending arbitration under Section 3 of the Federal Arbitration Act.
Stay meaning pause, not dismiss.
Correct. The court keeps the case on its docket but hits pause while the parties go arbitrate. In 2021, the district court agrees the arbitration agreement covers Jules' claims and orders the stay. Jules then proceeds to arbitration.
And how did that go for him?
Badly. In 2023, the arbitrator issues a final award ruling against Jules on every single claim. But it gets worse. The arbitrator also awards approximately $34,500 in sanctions against Jules based on misconduct by Jules and his attorney during the arbitration.
What kind of misconduct?
Jules refused to participate in the arbitral hearing on his own claims. Just didn't show up to argue his case.
That'll do it.
So now the employer, respondents in this case, return to the same federal district court that stayed the case back in 2021. They move to confirm the arbitral award under Section 9 of the Federal Arbitration Act. Confirming the award converts it into a federal court judgment with all the enforcement power that comes with that.
But Jules fights back.
Jules opposes confirmation and files his own motion to vacate the arbitral award under Section 10 of the FAA. Section 10 allows courts to throw out arbitration awards for very narrow reasons: corruption, fraud, arbitrator misconduct, arbitrators exceeding their powers. But here's where Jules makes an interesting jurisdictional argument. He says, wait a minute, this court lacks jurisdiction to confirm or vacate this award.
Why would a federal court lack jurisdiction when it's the same court that handled the case originally?
Because Jules argued that once the arbitrator issued an award, the only thing left are these Section 9 and Section 10 motions. The motions to confirm or vacate. And those motions themselves don't present any federal question. They're just asking about whether an arbitration award should stand. No federal statute gets interpreted. No federal right gets vindicated. Just contract stuff.
And diversity jurisdiction didn't work either?
Nope. Diversity jurisdiction requires two things: complete diversity, meaning parties from different states, and more than $75,000 at issue. Here, the parties lacked complete diversity and the amount in controversy fell below that $75,000 threshold.
So Jules argued the federal court lost its jurisdiction once arbitration ended.
Precisely. The district court rejected that argument and confirmed the arbitral award. Jules appealed to the Second Circuit, which affirmed. Then Jules petitioned the Supreme Court, pointing to a circuit split on this exact question.
The Fourth Circuit read a recent Supreme Court case called Badgerow versus Walters broadly, saying federal courts need independent jurisdictional bases for all Section 9 and Section 10 motions, even in pre-existing lawsuits. But the Second, Third, and Seventh Circuits limited Badgerow to freestanding applications, meaning cases where parties file arbitration motions directly in federal court without any pre-existing lawsuit. The Supreme Court granted cert to resolve this split.
Okay, so what exactly does the Federal Arbitration Act say about all this?
Section 3 says that when a federal court finds that claims in a lawsuit belong in arbitration under an agreement, the court shall, on application of one of the parties, stay the trial of the action until such arbitration has been had. Notice it says stay, not dismiss. The Supreme Court recently emphasized this in a case called Smith versus Spizzirri from 2024.
So the case stays on the court's docket during arbitration.
Right. Then Section 9 allows parties to apply to a court for an order confirming the award, and the court must grant such an order unless the award is vacated, modified, or corrected under Sections 10 and 11. Section 10 lists the narrow grounds for vacating an award: corruption, fraud, undue means, arbitrator partiality, arbitrator misconduct, or arbitrators exceeding their powers.
And Section 9 and Section 10 don't contain any magic jurisdictional language saying federal courts automatically have jurisdiction to handle these motions?
Correct. Unlike Section 4, which deals with compelling arbitration, Sections 9 and 10 lack special jurisdictional hooks. That silence drove part of Jules's argument.
So what's the legal question the court answered?
Whether a federal court that stays claims in a pending action under Section 3 of the FAA retains jurisdiction to confirm or vacate the resulting arbitral award under Sections 9 and 10, even when those motions don't independently present a basis for federal jurisdiction. In normal person language, can the same federal judge who pressed pause on your federal lawsuit also press play at the end and confirm or reject the arbitrator's decision?
Perfect way to put it. And the court said yes, unanimously.
Walk me through the reasoning.
The court started by distinguishing this case from Badgerow versus Walters, that 2022 case Jules relied on. In Badgerow, the parties went straight to arbitration without ever filing a lawsuit anywhere. Only after the arbitrator issued an award did one party show up in federal court asking to confirm or vacate it, a freestanding application with no pre-existing case.
So no federal lawsuit came first.
Correct. In that scenario, the court said you can't use something called the look-through approach, where a court looks through the arbitration motion to the underlying dispute to find federal jurisdiction. The court called that approach highly unusual and said Section 4 authorizes it because of specific save for language in that section. But Sections 9 and 10 lack similar language.
But this case involved different facts. Jules filed a federal lawsuit with federal claims before anyone mentioned arbitration. That lawsuit gave the district court federal question jurisdiction under Title 28, United States Code, Section 1331, which grants federal courts jurisdiction over civil actions arising under the Constitution, laws, or treaties of the United States.
So the federal court already had jurisdiction from day one.
Exactly. And here's the court's key move. Jurisdiction to decide a case includes jurisdiction to decide motions within that case. The court pulled this principle from Badgerow itself. Usually, the court explained, there's no need to look through a motion searching for jurisdiction outside the court. You just look at the case already sitting in front of you.
That feels pretty straightforward.
It does. The district court possessed federal question jurisdiction over Jules's federal employment discrimination claims. That very jurisdiction authorized the court to decide whether the arbitration agreement covered Jules's claims before staying litigation. Then, and this matters, nothing in the FAA eliminated that jurisdiction while the parties arbitrated.
So the jurisdiction just sat there waiting.
Precisely. When the parties returned to court after arbitration with their Section 9 and Section 10 motions, the court retained the same jurisdiction to decide the case, and therefore jurisdiction to decide those motions, that it possessed from the start.
Wait, but didn't the arbitral award resolve Jules's original claims? Like, the arbitrator ruled against him on everything. Don't those claims go away?
Jules made exactly that argument. He said the award resolved his claims and functioned like a settlement or affirmative defense, so the court no longer needed to exercise jurisdiction. But the court flipped this argument completely.
How so?
The fact that the arbitral award might have resolved Jules's original claims only underscores why the district court's original jurisdiction extends to the parties' Section 9 and Section 10 motions. Those motions required the district court to assess whether grounds existed to vacate the award under Section 10. So the motions proved integral to determining whether the award would continue serving as a valid defense to the original claims that remained pending, still technically alive on the docket, until the court confirmed the award.
So the claim stayed pending, just frozen, until someone confirmed the award or threw it out. And the court drew a comparison to other contexts where federal courts embody private agreements into court orders. In a case called Kokkonen versus Guardian Life Insurance Company of America from 1994, the court held that federal courts can incorporate private settlement contracts into dismissal orders when resolving pending claims.
I've seen that with class action settlements.
Exactly. The court pointed to consent judgments and class action settlements where federal courts routinely resolve disputes over private settlements and embody those settlements in court orders. In each scenario, including this one, parties reach a contractual resolution of claims filed in federal court, and the federal court retains jurisdiction to resolve disputes over that private settlement and convert it into a court order.
But confirming an arbitration award goes a step further than just recognizing a settlement exists, right?
Jules raised that point. Section 13 of the FAA says an order confirming an arbitral award carries the same force and effect as a judgment in a federal action. So Jules argued this exceeds what courts normally do with settlements. But the court said federal courts already possess this power. They embody settlements into orders with enforcement power all the time.
How did the FAA's overall structure factor into this?
The court cited Smith versus Spizzirri, that 2024 case about mandatory stays. Spizzirri held that Section 3 requires a stay rather than dismissal when sending parties to arbitration. Why? Because the stay comports with a supervisory role that the FAA envisions for the courts, including assisting parties in arbitration and facilitating recovery on arbitral awards.
So the stay serves a purpose.
Right. Under the rule the court adopted today, this scheme works smoothly. The FAA requires a stay, so a court that granted a Section 3 stay can superintend the arbitration to the end, including through confirmation or vacatur under Sections 9 or 10. But under Jules' theory, courts that grant mandatory Section 3 stays would have little to do except wait until arbitration concludes and then dismiss the claims.
Which would make the stay requirement pretty pointless. The court said it would be curious for Section 3 to mandate keeping cases on federal dockets for essentially no reason at all in the cases where federal interests are likely at their highest, those like this one involving live federal questions.
What about Jules's argument that Badgerow created a comprehensive jurisdictional scheme?
The court rejected that hard. Jules argued Badgerow converted the non-jurisdictional FAA into a complete jurisdictional framework requiring independent jurisdictional bases for all Section 9 and Section 10 motions. But the court said that overread Badgerow. The problem in Badgerow arose because, without the look-through approach authorized by Section 4, no federal jurisdiction existed anywhere in that case. Sections 9 and 10 lack the textual authorization for looking through to disputes outside the court, so Badgerow held that approach unavailable for freestanding applications.
But here, respondents weren't asking for any unusual look-through rule.
Correct. The court secured federal jurisdiction in the most usual way imaginable, based on the federal claims Jules filed in federal court under Title 28, Section 1331. Respondents simply asked the district court to use the FAA's tools to finally resolve those federal claims.
Now, Jules raised policy concerns.
Jules warned, this ruling would encourage parties to engage in useless federal litigation just to create a jurisdictional anchor for later confirm or vacate proceedings. He also worried federal jurisdiction would turn on the happenstance of whether someone filed a federal case before proceeding to arbitration. The court bought none of this. The court called Jules's concerns about protective anchor suits conjectural. Even courts that long embraced both Badgerow's rule for freestanding motions and today's result for pre-existing cases show no epidemic of useless filings clogging federal courts. The court noted this might occur because filing a precautionary federal anchor suit risks forfeiting the right to arbitrate altogether, or because securing a post-arbitration federal forum proves not very valuable to parties who cannot predict whether they'll emerge from arbitration as winners or losers.
So, bottom line, the court unanimously held that a federal court that stays claims in a pending action under Section 3 of the FAA retains jurisdiction to confirm or vacate a resulting arbitral award on those claims under Sections 9 and 10 of the FAA, regardless of whether those motions independently present a basis for federal jurisdiction. The court affirmed the Second Circuit's judgment.
Time for what this actually means. So what actually changes after this decision?
Well, this resolves a circuit split and clarifies that federal courts maintain continuous jurisdiction over federal claims throughout the arbitration process and its aftermath. For parties who file federal lawsuits triggering arbitration, like employment discrimination suits, civil rights cases, federal securities claims, you no longer need to worry about losing access to federal courts after arbitration concludes.
And that ripples out to streamline the entire arbitration process. All proceedings, from the initial stay order through final confirmation or vacatur, can occur in a single federal forum when federal claims launch the case. This prevents wasteful dual-track litigation where federal courts handle arbitrability appeals while state courts simultaneously handle confirm or vacate proceedings on the same award.
The decision also reinforces what the court called the supervisory role articulated in Spizzeri, meaning the FAA's mandatory stay requirement serves a real purpose, keeping federal courts engaged throughout arbitration so they can see cases through to final resolution. The stay isn't just administrative busywork. It anchors federal jurisdiction from start to finish.
What questions did the court leave open?
The big one, what happens when parties proceed directly to arbitration without first filing any lawsuit? Badgerow continues to govern those freestanding applications. So if you and I sign a contract with an arbitration clause, skip court entirely, go straight to arbitration, and then I show up in federal court asking to confirm the award, that's still a Badgerow situation. I still need independent federal jurisdiction like diversity or a federal question appearing on the face of my motion.
This ruling only covers cases where a federal lawsuit came first.
Exactly. But in practice, that covers a massive number of arbitration disputes, because lots of arbitrations begin with someone filing a lawsuit that then gets stayed. Employment cases, consumer protection suits, civil rights claims, these often start in federal court before arbitration kicks in.
And practically speaking, your mortgage, criminal record, medical lawsuit, pension, none of those get directly affected by this procedural ruling. But if you ever wind up in federal court over a federal claim and get sent to arbitration, you now know the same judge who sent you there will be the one who decides whether the arbitrator got it right.
Bottom line,
federal jurisdiction doesn't evaporate just because parties temporarily leave court to arbitrate. The court that pressed pause gets to press play, and that makes the whole system work more smoothly. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
you know what I love about unanimous decisions? It means we get to spend more time on the reasoning and less time refereeing judicial food fights.
Although sometimes those food fights make better podcast episodes.
Fair point. But I'll take judicial harmony when I can get it. Talk to you soon.